Moving right along, another motherfucking win against the goddamn leftist communists we were talking about at the beginning. The Supreme Court rules against illegals applying for citizenship.
Winning.
If you come here illegally and you get temporary asylum status for whatever reason and you can't get booted out, you can also not apply for fucking citizenship because you came here the wrong fucking way. And that is a win. That is how it's supposed to be fucking done. And I'm fucking so happy that we're finally putting our goddamn foot down and we're fucking doing what needs to be done. Let's get into this story though. Supreme Court rules against immigrants seeking green cards. The justices say immigrants with temporary protected status who entered the country without authorization may not apply for lawful permanent residency, and I am so fucking happy they did that.
Winning.
So fucking happy. The Supreme Court ruled unanimously on Monday that immigrants allowed to stay in the United States temporarily for humanitarian reasons may not apply for green cards if they had entered the country unlawfully. The case Sanchez versus Mayorkas, number 220-315, could affect tens of thousands of immigrants. It was brought by Jose Sanchez and Sonia Gonzalez, natives of El Salvador, who entered the United States unlawfully in the 1990s. In 2001, after an earthquake devastated El Salvador, the United States made the country's nationals eligible for the Temporary Protective Status Program. The program shields immigrants from parts of the world undergoing armed conflicts and natural disasters from deportation and allows them to work in the United States. But you're going to have to fucking leave to apply for citizenship, and that's the way it should be.
Winning.
The amount of money you paid to smuggle your ass in here, you could have paid to become a motherfucking citizen. Mr. Sanchez and Mrs. Gonzalez, a married couple, were granted protections under the program in 2014. They applied for lawful permanent residency, commonly known as green card, after their application was denied. They sued. The United States Courts of Appeal for the Third Circuit in Philadelphia ruled against them, saying that they were ineligible under a part of the immigration laws that require applicants to have been inspected and admitted into the United States. Temporary protective status. Judge Thomas M. Hardiman wrote for the unanimous three-judge panel does not constitute a demission. As its name suggests, he wrote that the protection is meant to be temporary. Justice Ellen Kagan, writing for the Supreme Court on Monday, agreed, saying that the two parts of the immigration laws operate on separate tracks. One part allows people who have entered the country lawfully to apply for a green card. The first part imposes an admissions requirement twice over, she wrote. It says that applicants for green cards must have been inspected and admitted or paroled into the United States, and it adds that people who have worked in the United States without authorization, as Mr. Sanchez has, before he was granted temporary protected status, are eligible only if their presence in the United States was pursuant to lawful admission.
That's how winning is done.
Pursuant to lawful admission. The other relevant part of the immigration laws, Justice Keegan wrote, allows immigrants, whether they entered the country lawfully or not, to apply for temporary protective statuses or TPS. The government may designate a country for the program when it is best beset by especially bad or dangerous conditions, such as arises from a natural disasters or armed conflict, she wrote. The country's citizens, if already present in the United States, may then obtain TPS. That status protects them from removal and authorizes them to become work here as long as the TPS designation lasts. The two tracks can sometimes merge, Justice Keegan wrote, and the recipient of temporary protective status entered the country lawfully, but she added that people who entered without authorization do not become eligible for a green card thanks to temporary protective status. Lawful status and admission, as the court below recognizes, she wrote, are distinctive concepts in immigration law, establishing one does not necessarily establish the other. On one hand, the foreign national, I can't even fucking read today, huh? On the one hand, a foreign national can be admitted but not in lawful status. Think of someone who legally entered the United States on a student visa but stayed in the country long past graduation. Justice Keegan wrote. On the other hand, a foreign national can be in lawful status but not admitted. Think of someone who entered the country unlawfully but then received asylum. The latter is the situation Sanchez is in, except that he received a different kind of lawful status. Because the grant of TPS does not come with the ticket of admission, she wrote, it does not eliminate the disqualifying effect of the entry laws. And I mean, that is what it is. It is what it is, and it is what it is. Like I said before, it costs 15 to 20 to 30,000 sometimes for these coyotes to smuggle people into this motherfucking country, and that is about how much it fucking, that's actually more than it costs to actually come here legally. So why can't you fucking people come here legally even when you're trying to flee like that? You can apply for asylum or whatnot or legal entry at the fucking border without fucking crossing it, or at the nearest fucking U.S. embassy to where you're leaving without fucking coming into our land. That is how it fucking works. If you can't respect our rules and shit, why should we let you here? Why should we let you in if you're not going to? I know you can get a better life here and all that, but that's not enough. You wanting a better life is not enough. If you can't respect us and our way of life, why the fuck should we let you here? That does not make sense to me. We shouldn't fucking let you here because you didn't come here the fucking right way. I'm just fucking saying.